Hello, everyone. Welcome back to our YouTube channel. Today, we have an exciting topic lined up. We will be diving deep into a question from the Notarial Practice exam written on November 18, 2023. Question 1. Specifically asked about the guidelines laid down in Ex Parte Oxford, 1920 CPD 367, for a court application to register a postnuptial contract. If you're preparing for similar exams or just interested in the topic, you're in the right place. But before we begin, if you're new here, don't forget to hit that subscribe button and ring the notification bell so you never miss out on our exam tips and legal discussions. In the case of Ex Parte Oxford, 1920 CPD 367, the court established clear criteria for registering a postnuptial contract. According to this ruling, certain steps needed to be followed. 1. Affidavit requirement. Firstly, both parties involved must sign an affidavit. This legal document is crucial in affirming the authenticity and consent of both individuals. 2. Premarital agreement. Before the marriage was solemnized, there should have been a mutual agreement, whether spoken or unspoken, between both parties to marry with the understanding of keeping their properties separate. 3. Reasons for lack of notarization. There should be valid reasons explaining why the agreement wasn't formalized through a notary and registered in the deeds office. This requirement emphasizes the need for a clear justification for any deviation from standard legal procedures. 4. Timely application. The parties must file the application promptly after realizing that they had mistakenly entered into a marriage where their properties were shared. This timely action signifies the importance of addressing the issue as soon as it comes to the parties' attention. 5. Submission of contract copy. Along with the application, a copy of the postnuptial contract must be submitted. This ensures that the court has access to the specifics of the agreement while processing the application. 6. Protection of creditors' rights. Additionally, the court emphasized the need to safeguard the rights of creditors when making this decision. This suggests that the court must consider the financial obligations and interests of third parties to maintain fairness in the legal process. In essence, Ex Parte Oxford, 1920 CPD 367, outlined a comprehensive set of guidelines, focusing on the legal formalities, mutual consent, justifiable reasons for procedural deviations, prompt action, document submission, and the protection of external stakeholders' interests. These guidelines serve as a framework for any future cases involving the registration of postnuptial contracts, ensuring a fair and transparent legal process for all parties involved. Question 2. 2.1 Joe, Jill and June are the co-owners in equal shares of the farm Muaplaz. Jill requests you to draw up her will, in term of which she inter alia bequeaths her 1/3 share in the farm in equal parts to Joe and June. Advise Jill on the legal position and the practical execution of such a bequest. In this situation, Jill intends to leave her 1/3 ownership share in the farm Muaplaz to Joe and Jane in equal portions. To comprehend the legal implications and the practical execution of this bequest, the following aspects need to be considered. Step 1. The legal position. First, let's talk about the legal aspect of Jill's bequest. There's this law, known as Section 3(c) of Act 70 of 1970. What's that, you ask? Well, this legal provision basically says that you can't just keep dividing up a piece of agricultural land. And, yep, you guessed it, Muaplaz is considered agricultural land. So, there's a legal restriction against chopping up this farm into smaller pieces. Step 2. Practical execution. But here's the exciting part, we're not stuck. There's a way to make Jill's bequest work within the law. Let's dive into the practical steps. Step 2.1. Transfer with simultaneous certification. Jill can actually give her 1/3 share of Muaplause to Joe and Jane without jumping through a bunch of legal hoops. How? Well, she needs to follow a specific process. One key element is getting a certificate of registered title. This certificate covers each co-owner's entire undivided share of the land. It's like a big, legal seal of approval. Step 2.2, increasing Joe and Jane's shares. So, when Jill goes through with this process, Joe and Jane's ownership shares effectively increase. This makes sure that the farm is still divided in line with the undivided shares of all the co-owners. Step 2.3, no separate dealing. Here's another important thing, this process also stops Jill's share from being bought or sold separately. It's like keeping the farm together as a whole, which is super important because it keeps us on the right side of the law when dealing with agricultural land. In a nutshell, what Jill wants to do is totally doable, and it's all about following the right steps. The legal framework might seem a bit tricky, but when you break it down, it's all about making sure that everybody's rights and the law are respected. Question 2.2. Y wishes to let a section of his farm on a long-term basis to X. Name the essential requirements that must be met before the lease contract will be accepted for registration. In this scenario, where Y wants to lease a section of his farm to X on a long-term basis, there are essential requirements that must be met before the lease contract can be accepted for registration. Let's break down these requirements. 1. Written contract executed by a notary. Firstly, the lease contract must be in writing. This means that all the terms and conditions of the lease must be clearly documented in a written agreement. Additionally, the lease agreement should be executed by a notary public. Notarization adds a layer of legal authenticity and credibility to the contract. 2. Survey of the leased land and SG diagram. Since only a specific part of Y's farm is being leased, it's crucial to have the land surveyed. This survey delineates the exact boundaries and dimensions of the leased section. An SG diagram, Surveyor General Diagram, representing the surveyed part of the land must accompany the deed of lease when it's submitted for registration. This diagram provides a visual representation of the leased area, ensuring clarity and accuracy. 3. Consent of the minister under the Subdivision of Agricultural Land Act 70. Before the lease contract can be registered, it's necessary to obtain the consent of the minister in accordance with the Subdivision of Agricultural Land Act 70. This step is particularly important when dealing with agricultural land, as it ensures compliance with legal regulations governing the subdivision of such properties. In summary, for Y's lease contract with X to be accepted for registration, it must be in writing, executed by a notary, accompanied by a survey of the leased land along with an SG diagram, and supported by the consent of the minister as per the Subdivision of Agricultural Land Act 70. By fulfilling these essential requirements, the lease agreement can be properly registered, providing legal clarity and protection to both parties involved. Question 3. X is the owner of a residential ERF in town which she leases to Z. X is also the holder of a usufruct over the farm, Morson, just outside the town where she farms. X borrows money from a family member Y. X instructs you, a notary, to draft and register in the deeds registry a notarial bond over these two assets in favor of Y as security for payment of the debt. Fully explain whether you will be able to execute the instruction to X's ability to execute the instruction to create a notarial bond over her assets. 1. Notarial bond for the residential ERF. Is feasible. X, as the owner of the residential ERF in town, can indeed create a notarial bond in favor of Y over this property. This is a common form of security used to guarantee debts, and X has full rights to hypothecate her ownership interest in this residential property. 2. Notarial bond over the farm Morson. is not feasible. Due to usufruct, the situation is different regarding the farm or son. X holds a usufruct over the farm, which is a limited real right. A usufruct, being a personal servitude, doesn't grant full ownership of the property to X. Instead, it grants specific rights such as the right to use and enjoy the property. These rights cannot be hypothecated or used as collateral for a notarial bond. Automatic termination with usufruct lapse. Importantly, if the usufruct were to lapse, whether due to waiver, expiration, or the death of the holder, X, the notarial bond over the farm or son would automatically terminate. This is because the bond is tied to the existence of the usufruct. Once the usufruct ceases to exist, the bond ceases as well. Conclusion. In summary, X can proceed to register a notarial bond over her residential IRF in favor of Y, as it is a fully owned property. However, regarding the farm or son, where X holds a usufruct, creating a notarial bond over the property is not feasible due to the nature of the usufruct. Even if such a bond were created, it would automatically terminate if the usufruct were to lapse. Therefore, the instruction can be executed only partially, securing the residential IRF but not the farm or son. Question 4. 4.1. When may the Master of the High Court remove a trustee of a trust? The Master of the High Court has the authority to remove a trustee of a trust under several specific circumstances, as outlined in the Trust Property Control Act. Here are the situations in which the Master can remove a trustee. 1. Conviction of offense involving dishonesty. If the trustee has been convicted of any offense where dishonesty is an essential element, or any other offense for which they have been sentenced to imprisonment without the option of a fine, the Master can remove them from their office. 2. Failure to provide security. If the trustee fails to provide security to the satisfaction of the Master within 2 months after being requested to do so, or within any further period allowed by the Master, they can be removed. 3. Sequestration or liquidation of estates. If the trustee's estate is sequestrated, liquidated, or placed under judicial management, the Master has the authority to remove them from the trusteeship. 4. Declared mentally ill or incapable. If a competent court declares the trustee to be mentally ill or incapable of managing their own affairs, or if they are detained as a patient in an institution or as a state patient, the Master can remove them from the position of trustee. 5. Failure to fulfill duties. If the trustee fails to perform satisfactorily any duty imposed upon them by or under the Trust Property Control Act, or if they do not comply with any lawful request made by the Master, they can be removed from their role as a trustee. In summary, the Master of the High Court has the authority to remove a trustee if the trustee is convicted of a relevant offense, fails to provide security, undergoes sequestration or liquidation, is declared mentally ill or incapable, or fails to fulfill their duties as per the Trust Property Control Act or comply with lawful requests from the Master. Removal of a trustee under these circumstances ensures the proper administration and safeguarding of the trust property and beneficiaries' interests. Question 4.2. What should be contained in a power of attorney in order for it to be in line with the deed registry's requirements? 7. A power of attorney document should contain the following elements to be in line with the deed registry's requirements. 1. Specific and full description of the property. The document must contain a detailed and accurate description of the immovable property involved. 2. Owner's identity information. It must reflect the owner's identity number and marital status. 3. Conveyancer's license number. The document should include the conveyancer's license to practice number. 4. Witness signatures. The power of attorney must be signed by 2 witnesses who are over the age of 14 years. 5. Spousal consent, if applicable. If the owner is married in community of property, the other spouse will have to countersign the document. If the owner is married according to the laws of a foreign country, the foreign spouse will also have to countersign the power of attorney. These elements ensure that the power of attorney document meets the necessary requirements of the deed registry. Question 4.3. What are the supplementary provisions in respect of the debt and real security relationship that have to be contained in a notarial bond? In a notarial bond, the following supplementary provisions regarding the debt and real security relationship should be included. 1. Terms and repayment details. The document should specify the term of the principal debt, the interest rate, and outline the method, time, and place of repayment of the capital sum. If applicable, it should detail the repayment in installments and the associated interest. 2. Cost clause. The bond should contain a cost clause that outlines the principal debt, the interest rate on the principal debt, and the costs that are secured by the bond up to a specified amount. This clause defines the financial obligations covered by the bond. 3. Domicilia citandi et executandi. This clause specifies an address where legal notices and process documents related to the bond can be served. It provides a formal way for parties involved to receive official communications. 4. Acceleration clause. In case of non-payment or breach of terms, an acceleration clause allows the lender to demand immediate repayment of the entire outstanding debt. This clause accelerates the repayment schedule under specific circumstances. 5. Waiver of legal exceptions. The bond should include a description of the legal exceptions that are waived by the parties involved. Legal exceptions refer to certain rights or defenses that a party might have under the law. By specifying which exceptions are waived, the terms of the bond become clearer and legally binding. 6. Insurance responsibility. The document should determine who is responsible for insuring the property bound by the bond. This provision clarifies the obligations of the parties regarding property insurance, ensuring that the property remains adequately protected throughout the term of the bond. Including these supplementary provisions in the notarial bond helps establish clear terms and conditions for the debt and real security relationship, protecting the interests of all parties involved. Question 4.4. What are the required periods for the registration of a notarial bond in more than one deeds office? The required periods for the registration of a notarial bond in more than one deeds office are as follows. 1. First deeds registry. The notarial bond should be registered within 3 months of its execution at the first deeds registry. 2. Second deeds registry. If the bond is to be registered in a second deeds registry, it must be done within 1 month after the initial 3-month period at the first deeds registry. 3. Subsequent deeds registries. If the bond needs to be registered in additional deeds registries beyond the second one, it must be done within an additional month at each subsequent deeds registry after the initial registration in the second deeds registry. These specific timeframes ensure that the notarial bond is promptly registered in all relevant deeds offices, meeting legal requirements and securing the interests of the parties involved. Question 5. 5.1. Discuss the characteristics of servitudes. 6. Servitudes are legal rights that allow one party, the servitude holder, certain privileges or benefits over the immovable property of another party, the servient landowner. Here we will discuss the characteristics of servitudes. Number 1. Nulla residential sua servit. This Latin phrase means no one may have servitude over his own thing. In other words, a person cannot have a servitude over their own property. Servitudes involve 2 distinct parties, the holder and the servient landowner. 2. Servitus esse non potest. This principle states that a servitude cannot exist over another servitude. Servitudes are specific rights granted to individuals and cannot be further burdened by additional servitudes. 3. Civiliter modo. the holder of the servitude must exercise their right in the least prejudicial way, civiliter modo, concerning the owner of the servient land. This means that the servitude holder cannot excessively interfere with the use and enjoyment of the servient land. 4. Principle of passivity. A servitude cannot impose a positive obligation on the owner of the servient land. It means that servitudes generally restrict certain activities or require the owner to tolerate specific uses but do not require the owner to take active steps or perform actions for the benefit of the servitude holder. 5. Absolute and enforceable right. The right of the holder of the servitude is absolute and enforceable against the whole world. This means that the servitude holder can protect their right through legal action, such as the real remedy actio confessoria, if the servitude is violated by anyone, not just the servient landowner. 6. Limited real right. The holder of the servitude acquires a limited real right in respect of the owner's property. This limited real right grants the holder specific entitlements over the servient land without transferring ownership, allowing for a legal interest without full ownership control. These characteristics define the nature and limitations of servitudes, ensuring a balance between the rights of the servitude holder and the rights of the servient landowner. Question 5.2. How may servitudes be terminated? 7. Servitudes can be terminated through various means. Here are the ways in which servitudes may be terminated. 1. Cancellation by agreement or unilateral waiver. Servitudes can be terminated if both parties, the servitude holder and the servient landowner, agree to cancel it, or if the holder of the servitude unilaterally waives their rights. 2. Impossibility to exercise the servitude. If it becomes impossible to exercise the servitude, it can be terminated. 3. Expiration of time period. Servitudes can expire due to the lapse of time either when the period for which the servitude was originally granted expires or, in the case of a personal servitude, upon the death of the holder if it's a natural person, or after 100 years or earlier liquidation if the holder is a legal person. 4. Merger. If the holder of the servitude becomes the owner of the property encumbered by the servitude is terminated through merger. 5. Prescription. Servitudes can be terminated through prescription if the holder was prevented from exercising the servitude for an uninterrupted period of 30 years or if the holder refrains from exercising a positive servitude for an uninterrupted period of 30 years. 6. Legislation/expropriation. Servitudes can be terminated by legislation, such as in the case of expropriation, where the government takes over the property for public use, thereby extinguishing the servitude. These methods provide legal mechanisms for the termination of servitudes, ensuring that these rights can be dissolved under various circumstances. Question 5.3. X and Y executed their antenuptial contract while on holiday in the Kruger National Park in the presence of their friend, who is a notary public. Where will the antenuptial contract be registered? The antenuptial contract executed by X and Y in the presence of their friend, who is a notary public, can be registered in any deeds registry in the country. The registration of an antenuptial contract is not limited to the location where it was executed, where the parties reside, or where the notary public practices. Once registered in any deeds registry in the country, the antenuptial contract is valid and applicable throughout the entire country. Question 6. 6.1x, who owns a holiday home in Port Alfred, has been transferred abroad by his employer. X agrees with his neighbor, Y, to maintain the house and garden for a period of 10 years. X and Y execute, before you as notary, a notarial agreement and request you to register the agreement in the deeds registry. Will the Registrar of Deeds accept the conditions of the agreement for registration as a servitude or as any other registrable right? Briefly substantiate your answer by also applying the test used by the courts in this regard. The Registrar of Deeds is unlikely to accept the conditions of the agreement for registration as a servitude or any other registrable right based on the provided information and the principles applied by the courts. The agreement doesn't create a personal servitude because it doesn't grant Y any entitlements of use or enjoyment over the property of X. B. It doesn't qualify as a predial servitude either because it merely places a duty on Y to maintain the property without granting Y specific usage rights. C. The concept of a servient and dominant tenement, where one piece of land benefits from the other, is not applicable because there are no usage rights granted to Y. D. Servitudes generally cannot compel the owner of a servient tenement to perform a positive act, and the duty to maintain X's house does not fall within the usual scope of servitudes. E. The agreement doesn't create a registrable real right as it does not establish a specific legal interest in the property. F. The subtraction from dominium test is used to determine whether a right qualifies as a real right, and it must place a burden on the land that diminishes the owner's ownership. In this case, the duty to maintain X's house merely imposes a burden, which may not meet the criteria for registration as a real right. G. The duty to maintain X's house, being primarily an obligation, doesn't appear to meet the criteria for registration as a real right because it doesn't involve a significant diminution of Y's ownership. In summary, the agreement described doesn't seem to fit the criteria for registration as a servitude, predial servitude, or a registrable real right, according to the principles used by the courts and the information provided. Question 6.2. In respect of short and long-term lease, under which circumstances will Hoor-Got Voorkoop apply? The principle of Hoor-Got Voorkoop means lease takes precedence over sale. This principle determines the priority of rights between a lessee, tenant, and a third party who acquires rights over the same property, such as a buyer or creditor of the lessor, landlord. The application of this principle depends on the circumstances and the type of lease involved. 1. For short-term leases and the first 10 years of long-term leases, not registered. Applicability ** Hoor-Got Voorkoop applies in the case of short-term leases and during the first 10 years of a long-term lease that has not been registered. Conditions ** The principle applies if 1. The lessee is in control of the leased property. 2. The successor in title or creditor of the lessor had knowledge of the lease at the time the transaction affecting the leased premises was entered into with the lessor. 3. The successor in title of the lessor acquired their right under lucrative title, without giving value, even if they had no knowledge of the lease and even if the lessee is not in control. For long-term leases exceeding 10 years. Applicability ** Hoor-Got Voorkoop applies in the case of long-term leases exceeding 10 years. Conditions ** The principle is enforceable against creditors and successors under onerous title, who acquire for value, of the lessor if the lease agreement has been duly registered in the deeds registry, and the creditor or successor had knowledge of the lease at the time the credit was granted to the lessor or at the time of entering into the transaction with the creditor. In summary, for short-term leases and the initial 10 years of long-term leases, the principle applies based on the lessee's control, the knowledge of the successor or creditor, or the acquisition of rights without value. For long-term leases exceeding 10 years, the principle applies if the lease is duly registered or if the creditor or successor had knowledge of the lease at the time of their transaction with the lessor. Thank you all for watching ELA Law Tutorials. Your support and engagement mean a lot to us. We hope our tutorials have been helpful to you, and we look forward to providing more valuable content in the future. If you have any questions or topics you'd like us to cover, please feel free to let us know. Your feedback is important to us. Thanks again for being a part of our ELA Law Tutorials community, and don't forget to subscribe.